applicable having regard to the provisions of this act, unquote. What all that means is that where there is express provision in the act on a particular situation, such as it clearly is in paragraph 45B of the first schedule to the electoral act 2022, that says the election petition shall be accompanied by written statements of oath of witnesses, the provisions of the Federal High Constable Procedure Rules will not apply. Fortunately, there is again high authority in support of this position in the dictum of Muntaka Kumasi GSC in Nwankwo versus Yaradua, citation supplied, where His Lordship, after producing paragraph 50 of the first schedule to the Electoral Act, now paragraph 54, had this to say. Say from the above, it is crystal clear that the provisions of the Federal High Court rules are subject to the provisions of the first schedule of the Electoral Act 26, and if there is any conflict between them, the provisions of the rules under the Electoral Act will prevail. It is where there is a lacuna in the provision of the rules provided in the Electoral Act 2006 that the provisions of Federal High Court rules will apply. I shall also add that the Parliament has expressly stated without dichotomy in paragraph 45B of the first schedule that to the Electoral Act that petitioners shall front-load witness statements of their witnesses along with their petitions. It is not within the province of the court to give that provision a different interpretation. It is a moment that in the court's opinion, the same literal meaning of paragraph 45B of the first schedule to the Electoral Act 2022 seems harsh and may not meet the justice of the case, as is being suggested by the petitioners that subpoena is only issued to an unwilling witness, so it is not contemplated by paragraph 45B of the first schedule to the Electoral Act 2022 that the witness on subpoena should also depose to a witness statement before the subpoena to compel the attendance is served on him by the court. If anything, the argument brings to mind the very strong admonition of the British House of Lords Lord Denning MRL in Duport Steels Limited versus SIRS citation supplied, where the learned Lord Scammon in his speech said, but in the field of statute law, the judge must be obedient to the will of the Parliament as expressed in its enactments. In this field, Parliament makes and unmakes the law. The judge's duty is to interpret and to apply the law, not to change it to meet the judge's idea of what justice requires. Interpretation does, of course, imply
this was just announced to me now already. God, so
where
tired.
Different constructions is possible, but our law requires that the judge chooses the construction
This one doesn't know what to say. I'm busy tired.
best meets the legislative purpose of the enactment. If the result is unjust but inevitable, the judge may say so and invite Parliament to reconsider the provision. But he must not deny the statute. Palatable statute may not be disregarded or rejected merely because it's unpalatable. Only if a just result can be achieved without violating the legislative purpose of the statute may the judge select the construction which best suits his idea of what justice requires in any case. That is a settled position of the law, even in this country. See Ndomaeba and
you guys, I'm trying to get my tripod.
Coca-Cola Nigeria, Akinsanya, then Global Excellence, cited earlier, and Donald Duke. There, my Lord said, the duty of the court is not to deal with the law as it ought to be, but as it is. Paragraph 45B of the first schedule to the Electoral Act 2022, I will even venture to say further, appears to have been inserted by Parliament in further realization of the sui generis time-bound nature of the election proceedings, a point further driven home by the Constitution of the Federal Republic of Nigeria, Second Alteration Act 2010, which introduced, among others, a new section 285 sub 6 into the 1999 Constitution. That provision states that an election tribunal or court shall deliver its judgment in writing within 180 days from the date of filing of the petition. This time limit for disposal of proceedings, it must be noted, is peculiar to election petition proceedings in our body of laws. It is not found in any other proceeding in the entire body of laws of this country. It thus imposes on the election court or tribunal a duty to properly utilize its case management so pre-hearing session as effectively as possible to carefully plan the future course and particularly its plenary hearing of every petition so as not to fall foul of the maximum 180 days limit. That necessarily includes trimming the number of witnesses where necessary once pleadings are closed in the petition. That is also the point echoed by this court in People's Democratic Party and Chibuzo, Kobo, and others, citations supplied, where my colleague Abadwa JCA said, what is deducible is that witness deposition filed by a witness not listed in the petition cannot be countenanced by the court or tribunal after the expiration of the time prescribed for the filing of the petition. It was stressed also by this court hearing that to allow a petitioner to file an additional witness statement at any stage of the election proceedings would destroy the regulated environment that must exist to ensure that both parties to the petition are expeditiously heard and the petition determined within 180 days from the date of the petition. This court observed that such an indulgence will remove the control of the pace of the proceedings from the control of the Constitution, the Electoral Act, and the first schedule to the Electoral Act, and leave it at the whims and caprice of the parties and open the floodgates for all kinds of abuses of the judicial process. Quote. I think the same point is also deducible from the following.
Are you tired of announcing
in the dictum of Toby mentioned similar things in Warrior Nines. And then Warrior Nines also said a lot about that. We have mentioned it earlier. And then by rules of study decisis, the decision in OK and Mimico and Oba Vincent, decisions of this court is bound not only by decisions of the Apex Court, but also by its own previous decisions. And these are known issues. Victor, Rosek and ACB is there. And then ITBP Limited and UPN Limited. See the decision of Ugwa GSE. Long and short of all the foregoing is that the objection of the respondents to the witness statements of PW to Wuma Friday, PW 13, Grace Timothy, PW 14, Grace Ajabona, PW 15, Abidemi Joseph, PW 16, Ms. Dosa Obosa, PW 17, Ms. Aleri Ayuba, PW 18, Ms. Sadia Mohamed Aruna, PW 21, Mr. Samuel Odontan, the statistician, PW 23, Janet Nuhu Turaki, PW 24, Christopher Bulusado, PW 25, Victoria Sani, PW 26, Hitler Ewonu Mwala, forensic expert, and PW 27, Mr. Mike Enaureba, legal practitioner, which did not accompany the petition as required by paragraph 45A for the first schedule to the Electoral Act is hereby sustained, and the witness statements being incompetent are hereby struck out and expunged from the records of this court. Of the same first schedule to the Electoral Act 2022, stating that there shall be no oral examination of a witness during his evidence in chief except to lead witness to adopt his written deposition and tender in evidence all disputed documents or other exhibits referred to in the deposition. It follows that all the evidence, including evidence in cross-examination and all documents, reports included, namely PAH1, PAH2, PAH3, and PAH4, and PAR1A, PAR1G, PAR1C, PAR1D, PAR1E, and PAR1F, and PBD, PBD1A, PBD1B, PBD1C, PBD1D, PBD1A, PBD2, 1A, PBD2A, PBD3, PBD4, PBD1, PBE2, PBE3, PBE4, PBE5, PBE6, PBF1, PBF2, PBF3, and PBF4, coming from and tendered by the said petitioners' witnesses namely, as I already listed, PW 12, 13, 14, 15, 16, 17, 18, 21, 22, 23, 24, 26, and 27 aforementioned are incompetent and are hereby expunged from the records of this court. Other objections of respondents. That takes me to the other objection
I think it's Article's case.
raised by the respondents to the admission of documents tendered by petitioners at the hearing, which objections they only give notice that they will give reasons at final address stage. All three respondents filed their submissions on the objections and adopted them on 1st of August 2023. Petitioners on the same 1st of August also adopted their responses to those objections. Now, before going into the objections, we deem it necessary to first dispose of the preliminary argument of counsel to petitioners that some of the documents objected to by respondents are electoral material certified by the first respondent INEC, which documents parties are agreed at the pre-hearing session that they will not object to. So respondents cannot resile from that agreement and raise objection as they are doing. They even cited section 169 of the Evidence Act 2011 to say respondents stopped from resiling from that agreement. The simple answer to that argument is that this court, and indeed every court, is bound to act on only admissible evidence. So if a document or piece of evidence is inadmissible in evidence, the court must expunge it, and it must do so even if that will require it to overrule its own interlocutory decisions admitting that evidence. See Shano and Afribank and other authorities in that respect. As counsel, as ministers in the Temple of Justice are therefore within their right and in fact duty bound to draw court's attention to that fact, regardless of whatever agreement they may have had with petitioners at the pre-hearing session. In any event, the court is only bound to honor lawful agreements, not unlawful ones, to admit evidence that may well be inadmissible. With that said, I now proceed to the objections as contained in the addresses filed by respondents. Here, I shall take them together as I have done if reasons now advanced for them were canvassed earlier. Now, let's look at first respondents' alleged allegation of improper or non-certification of INEC documents. Answer to the first respondent in paragraphs 1.34 to 1.36 of first respondent's written address filed on 14th of July 2023. Second respondent at paragraph 3.13 of his 20th of July 2023 address. And third respondent in paragraph 1.14 of his written address on objections filed on 14th of July 2023 all argue that the payment for certification is one under section 104 of the Evidence Act 2011 for certification of public documents. They say petitioners did not pay for certification of some INEC documents, specifically exhibits PAJ1, PAJ 37, PAJ 38, PAJ 39A to F, PAJ 40, PAJ 41 to PAJ and PAJ 41 to PAJ 7. There's something wrong. PAK1, PAK13, PAL1, PAL2, PAQ to PAQ14, exhibits PAS1 to PAS20, exhibit PAT1 to PAT17, then PAU1 to PAU17, PAV to PAV20, PAW1 to PAW25, PAX1 to PAX13, PAY1 to PAY18, PAZ1 to PAZ17, PBA17 to PBA27, PBB1 to PBB21, and did not provide any evidence of payment of certification fees. Senate Council, all citing the cases of Tabik Investment and GTB, Jimon, Minister of Federal Capital, Emeka and Chuba Ikweazu, argued that certification fees for the same documents having not been paid by the petitioners, the documents remaining admissible and liable to be expunged from the records. Petitioners' response argued in paragraph 4.1 and paragraph 6.0 to 6.2, paragraph 2.123 of their response to second respondent, and paragraph 2.16 to 2.7 of their response to third respondent, that they actually paid certification fees to first respondent for their said documents, and that there were issued receipts by the first respondent. Some of those receipts, they say, were attached to the documents themselves, while others were separately receipted for, including in one instance payment of 6,669,301 naira 25 kobo.
See this wicked governor, the governor of
Kogi State, 7 naira 50 kobo. They argued that it was therefore unconscionable of first respondent who collected such huge sums of money from them to turn around and plead non-payment of certification fees. Then Senior Counsel on Petitioners' behalf also pleaded the Evidence Act's presumption of regularity of official acts and submitted that it was strange that a public institution like first respondent will come before a court of law to disown documents officially issued by it. In specific response to third respondent's argument, counsel to petitioners argued that section 1041 and 2 of the Evidence Act 2011 does not prescribe that the amount paid for certification must be reflected on the certified true copy of the document as part of the certification. So the argument of third respondent's counsel that because the certification of the said exhibits did not carry the amount paid for certification fees were not paid for is clearly erroneous. Now, section 104 of the Evidence Act provides every public officer having custody of public document which any person has a right to inspect shall give that person on demand a copy of it on payment of the legal fees prescribed in that respect, together with a certificate written at the foot of such copy that it is a certified true copy of such document or part of it as the case may be. Secondly, the certificate mentioned in subsection 1 of this section shall be dated and subscribed by such officer with his name and his official title and shall be sealed whenever such officer is authorized by law to make use of a seal, and such copies shall be called certified true copies. There is nothing in the foregoing provision, particularly subsection 2, dealing with what should appear on the certification, that suggests that the fees paid for certification of a public document should also appear on the face of the document, like the date, name, and official title of the public officer issuing the document, as required by subsection 2. Payment of certification fees is only a condition precedent to the certification, so it could be stated in any other place, including another document. That point, this court also made plain in answer to a similar argument in Dagash and Bulama, and where it was held that certification in fee contained a separate document is sufficient. In this case, not only is there certification fee payment by petitioners first in the form of SVPD, showing payment by petitioners to INEC of the sum of 150,967 naira 50 kobo for some documents. There is also a second INEC receipt in INEC's own letterhead and to SVPF 4C. This latter document evidencing further payment of certification sum of 6,696,301 naira 50 kobo by the petitioners, Atiku/PDP legal team, shows that it was made by the receipt number RRR 270-842-653235 and on INEX receipt number 069727 of 25th of May 2023. It specifically states on its face thus: the sum of 6,696,301 696,301 naira 25 kobo only, being payment for CTC IPO electronic of a copy of data level number or data level, although not very legible, with time, then stamp, event history, polling units of EC8As and S yet to be uploaded from EC9 and other documents 2023 presidential election on quote. All that, in my opinion, is sufficient evidence of certification fee payment. Even more so, when the receipt indicates that the same payment also covers other documents outside those specifically mentioned therein. The burden had thus shifted to the first respondent INEC to show that the monies it received from petitioners for certification fee payment did not cover the documents they are now talking about, which documents INEC interestingly also certified. That burden INEC never discharged, especially when account is taken of the fact that it did not even give the amount assessed, if any, that petitioners were owing them for certification. By the provisions of Section 1041 of the Evidence Act, an applicant for certification of public document is only obliged to pay what is assessed by the public officer. What is more, the mere fact that respondents certified the same documents for petitioners, coupled with the evidence of certification fee payment by petitioners in Exhibits PD and PAF 4C, sufficiently triggers the provisions of Section 168(1) of the Evidence Act 2011 that says when any judicial act or official act is shown to have been done in a matter substantially regular, it is presumed that formal requisites for its validity were complied with. This ground of the objection is therefore overruled. Then on the issue of alleged engravement of certification, it was also argued by the respondents relying on the Guru and Ahmed that certification of the same documents was done by public officer of INEC by engravement of his name, official title and date instead of subscription, so that also, he said, is invalidated the documents and rendered them inadmissible. I've carefully perused the same documents and verified that unlike Beguri and Ahmed, the documents in issue here bear the long-hand signature of the relevant certifying public officer of INEC. That, in our opinion, is substantial compliance with Section 104 of the Evidence Act and attracts the presumption of genuineness via Section 146 of the Evidence Act. First and second respondents in particular also argue that SBs PAH1, PAH2, PAH3, and PAH4 tendered by PW21 Mr. Samuel Johnson and SB PAR8 to F tendered by PW26 Mr. Hitler A. Mwala were made during pendency of this proceeding or in anticipation of it and therefore inadmissible in evidence by virtue of Section 83(3) of the Evidence Act 2011. In their response, the petitioners argued that the same documents were made pursuant to the orders of this court, pursuant to Section 146(1) of the Electoral Act 2022, permitting them to inspect documents, so they were properly before the court. Much as I am not oblivious of our earlier ruling that these same documents coming from witnesses whose witness statements on oath were not front-loaded with the petition are incompetent and so already struck out. I'm also of the opinion that the petitioners seem to completely misconceive the objection raised by the respondents, which is to the effect that the same documents having been undeniably made during the pendency of this petition or in anticipation of it are rendered inadmissible by the principal law guiding admissibility of evidence, the Evidence Act 2011 and Section 83 thereof, sub 3 thereof. It is therefore lame of the petitioners to find their breach of that provision on account of the orders of this court made pursuant to Section 146 of the Electoral Act 2022, that they be allowed to inspect polling documents in the custody of INEC. In any case, Section 146(1) of the Electoral Act 2022 merely states that an order for inspection of a polling document or any other document or packet in the custody of the Chief National Electoral Commissioner or any other officer of the Commission may be made by an election tribunal or a court of competent jurisdiction if it is satisfied that the order required is for the purpose of instituting, maintaining, or defending an election, unquote. This does not in any way give petitioners the leeway to adduce evidence in breach of Section 83 sub 3 of the Evidence Act 2011. Section 146 of the Electoral Act 2011 and the interim orders of this court only permitted the petitioners to inspect election documents for the purpose of instituting or maintaining an election petition. Nothing in that provision allows a petitioner to file evidence, let alone the bulky expert reports as in exhibits PAH 1 to 4, PAH 1 AF, PAR 1 A to F during the pendency of the petition. The whole idea behind Section 83(3) of the Evidence Act 2011 is to specifically tailored in anticipation of a case or was to produce such fresh evidence after the case has begun and parties have fully joined issues in it. That is exactly what the petitioners sought to do with exhibits PAH 1 to 4 and PAR 1 A to F, prepared and filed by experts long after pleadings in the petition had closed, when respondents will no longer have opportunity of retaining their own experts to respond to the evidence presented against them in the same reports. I'm in agreement with the respondents and hereby uphold their objection that the said reports, which were admitted in evidence as exhibits PAH 1, PAH 2, PAH 3, and PAH 4, and PAR 1A, PAR 1B, C, D, and E and F are without prejudice to our earlier decision that our incompetent is also rendered inadmissible in evidence by virtue of Section 83 sub 3 of the Evidence Act 2022. Oh, sorry, Evidence Act 2011. Then the next one is the inadmissibility of election documents tendered as exhibits by petitioners on grounds of absence of pleading to support them and consequential relevance to the petition. The respondents' argument here are given. So we now skip that to the resolution. We've seen that, and the resolution what we have is, it appears clear to me that the respondents' objection here is misconceived and founded on isolated reading of paragraph 143 of the petition, where the petitioners aver that the first respondent and its agents wrongly and deliberately entered wrong scores results for the underlisted 22 states, namely
why do we even need to go to court?
Abia, Damawa, Akwa Ibom, Anambra, Bauchi, Bayelsa, Cross River Delta, Enugu, Gombe, Imo, Kaduna, Katsina, Kebbi, Niger, Osun, Taraba states. Pleadings, they said, of party is not read in that isolated manner to get at a party's complaint. Pleadings must be read holistically to get at the complaint in issue. If that is done as it should be done, the respondents will have come across where petitioners left no one in doubt that their complaint about the election is nationwide and not isolated to only some few states. That much is clear. First, from paragraph 107 of the petition, where petitioners averred that the petitioners shall give evidence to show that election results as purportedly declared by first respondent in respect of each state of the federation, including the federal capital territory, the details of which are contained in the table below, and table was given. Then they proceeded to list each of every state of the federation. They also gave in the table wrong election figures declared by INEC for each state and FCT. Then in paragraph 147 of the same petition, they listed 60 different types of sets of documents they intended relying on to prove the said environment. Paragraph 107 of the wrongness of the result declared by INEC for each state and the FCT. the presidential election. Among those documents listed by them are A, Beaver's CTC reports, B, Forms EC8 series, then EC8A, EC8B, EC8C, EC8D, EC8DA, EC8E, as a certificate of return received by petitioners' agents at the election. C, summary of the total registered voters on unit basis. D, summary of PVCs collected on unit basis. E, data and event logs from all BVAs
Judgment is being
used in the
delivered.
election. And F,